One of the things in the International and Comparative Law Research Center we are very proud of is that we try to be very, very punctual, and we try to start everything on time. So thank you very much for coming. My name is Julia Molina, and I have a real honor to say just a few words before we start the discussion. And I think that I really shall say something about the organization, but I'll try not to make it very boring. The thing is that most events on the Singapore Convention Week and on different arbitration weeks are usually organized by some organizations, someone which are in international commercial arbitration, international commercial dispute resolution. We are from the public international law area. And this event is an opportunity to look at different types of international dispute settlement from both public international law perspective, from commercial law perspective, because at the end of the day, it's all about dispute settlement. And maybe there are some common things to discuss, and I hope that they will be discussed, especially taking into account such a prominent panel. The International and Comparative Law Research Center is a non-governmental organization which is based in Moscow and which is not only about international dispute settlement, I must say. So we do have different research projects. We do prepare research papers on different topics of public international law. It's law of the sea, it's international trade law, of course, it's ISDS, climate change, plastic pollution. We'll be very, very happy if you are interested somehow in what we're doing. And if you join, for example, as researchers, if you join to our work in international organizations as observers, and we could share something and we could think of something together. So if you are somehow interested in research, please welcome. Again, thank you very much for coming. Please feel absolutely free today to ask questions, to share your experience, to share your thoughts. I think it's very important to make it very interactive, but I'm sure that our moderator and our speakers will definitely do it very interactive. And on this, I give the floor to Igor. Mr. Igor Fedorov is the head of research projects of International Comparative Law Research Center, especially on the topic of the law of the sea, but absolutely not only on this topic. Thank you very much, Igor. Please enjoy the discussion.
Thank you, Julia, for your welcome remarks and passing on the floor to me and the panel. Distinguished panelists, dear participants, dear colleagues, as noted by Ms. Mulna, my name is Igor Fedorov, and it is a pleasure to be here and the privilege to moderate a panel of such renowned experts and practitioners in the field of international law and international dispute settlement. The role I was trusted today is rather limited. However, I do look forward to assisting us all in navigating through the discussion of our head topic. And just a few remarks as a matter of introduction. The settlement of disputes is one of the key functions of law. In international relations, peaceful settlement of international disputes plays a central role. It is a prerequisite to the maintenance of international peace and security. In commercial relations, predictable, efficient, and reliable mechanisms for resolving disputes promote the flow of business, encourage investments, and facilitate international trade. We have seen how, primarily over the last century, the system of dispute resolution in interstate, investor-state, and commercial domains has been developing. Some means of dispute settlement were more percipient to the needs and challenges of time, and some were not. As a result, certain mechanisms and bodies passed to history, and some international courts and tribunals have emerged and flourished. More recently, we have also witnessed how new technologies have impacted the scope of existing disputes and their settlement. So the idea of our discussion today is to explore current and emerging trends, including possible reforms across various domains and forms of international dispute settlement. And the hope is that at the end of the day, we may possibly draw on some shared trends and distinct trajectories, as well as on the best practices and possible lessons to be learned as between different international dispute settlement frameworks. And helping us to sail towards those goals, we are privileged to have a panel of renowned experts and practitioners, including Mr. Roman Kolodkin, judge at the International Tribunal for the Law of the Sea and advisor on public international law at the International Comparative Law Research Center, Ms. Alina Miron, professor at the University of Angers in France and partner at FAR Avocat, Mr. Ong Ching Heng, Senior Director and Senior State Counsel at the International Affairs Division of the Attorneys General's Chambers of Singapore, Mr. Francis Xavier, the Regional Head of Disputes Group at the Raja and Tan Singapore, and Mrs. Ji Xiaoxie, Senior Legal Officer and Head of Negotiation and Research Division of the Preparatory Office of the International Organization for Mediation, or IOMID. Thank you very much to all of you for being with us today. And as noted already, the idea was to bring together perspectives from different domains: interstate, investor state, and commercial. And we will begin with the settlement of interstate disputes, which will be addressed by Judge Kolodkin and Professor Miron. Judge Kolodkin, Professor Miron, we have seen how since 80s and 90s of the previous century, the idea of solving interstate disputes in courts regained its popularity. And the concept of judicialization of international relations started to gain prominence. In the International Court of Justice, for example, before 1990, within the first 45 years of the court, slightly over 70 cases were registered. Now, there are about 200 of them, including 23 cases pending before the court. In the 1990s, compulsory interstate dispute settlement procedures were also integrated within the WTO and under the United Nations Convention on the Law of the Sea. Until now, WTO panel reports have been adopted with respect to around 300 cases, and more than 40 cases altogether have been dealt with by the International Tribunal for the Law of the Sea and arbitral tribunals established under Annex 7 to UNCLOS. We have also witnessed the renaissance of the Permanent Court of Arbitration that is currently acting as a registry in around 200 cases involving states and state authorities. If one adds to this regional courts and their caseload, judicialization of international relations becomes apparent. At the same time, more recently, a number of criticisms have been addressed to international courts and tribunals, irrespective of whether they are universal or regional, permanent or ad hoc, general or specialized. In this context, Judge Kolodkin, we would very much appreciate your thoughts on the current trends and challenges in interstate dispute settlement. And after you, we will then proceed with Professor Miron. So, Judge Kolodkin, the floor is yours.
Thank you, Mr. Fedorov. Thank you, Igor, very much for giving me the floor. Good afternoon. Sorry. Good afternoon, everyone. It's a pleasure and honor for me to participate in this event and to participate in the Singapore Convention. This is my first time here. I'm going to address you in my personal capacity. It's a usual disclaimer for me. So nothing of what I will tell you should be attributed to either my tribunal, the International Tribunal for the Law of the Sea, or to the International and Comparative Law Research Center. In his declaration to the recent advisory opinion of the International Court of Justice on climate change, Judge Nolte notes that many people and states are pinning their hopes of addressing the issue of climate change, particularly on international law and international courts. At the same time, he also points to the limits of the international court's role and emphasizes the crucial importance of states' reaction to the court's decisions. And I have to say that we all see that states' attitudes towards international courts and their decisions are really divergent. There is obviously a growing number of states from different regions that are turning to international courts to settle disputes or controversies, which they cannot resolve through other non-judicial means. What also seems to be a recent trend are numerous interventions of third states in the judicial proceedings. Additionally, visibly popular have become requests for provisional measures. These judicial actions seem to demonstrate not only an interest of a growing number of states in international justice, but also, to a certain extent at least, an interest of at least some of them to employ international courts as a means of exerting pressure on the opponents. It's not by chance, of course, that the term lawfare became, I should say to my regret, rather popular, describing judicial action taken by some states against others. What seems to be an interesting, though probably not a completely new development here, is that states are turning to courts to seek solutions that they cannot achieve through the multilateral global processes. And lately, this seems to be increasingly done not through the dispute settlement procedures, but using international courts' advisory function. As one state's representative put it recently, asked about the climate action before international courts, we are not getting the action we need at the negotiation table. So we are turning to international law. And international law here equals international courts. Lately, we have seen a streak of requests for advisory opinions concerning climate change in different international judicial fora, regional, universal, quasi-universal. Notwithstanding the absence of global judicial hierarchy or system, international courts applying public international law generally tend to be consistent in their legal positions, generally. As stated by the ICJ, the point here is to achieve the necessary clarity and the essential consistency of international law. The expanding fabric of international jurisprudence plays an important role in the determination of law as it is, and is increasingly referred to not only internationally, but by national courts as well. This particularly prompts those who deal with courts to plan in which sequence to engage them. And this kind of planning seems to become another nowadays feature. While it's true that many states are placing their hopes on international courts, the attitude of others differs. One may observe that there are states that continue to look on international courts with suspicion, and more broadly are prone to turn to coercion when they consider peaceful means of dispute settlement to be not sufficiently effective or exhausted. These states will believe that no international authority could be above them and perceive at least a part of international law and international courts as a menace to their sovereignty. This lack of trust may further be further fueled by issues arising in the functioning of international judicial bodies. It may also be nourished by what is labeled by some commentators as judicial activism, in particular by the court's inclination to assert their jurisdiction in the contended circumstances, despite opposition of those states which insist that the limits of their consent upon and within which the jurisdiction in question was constituted would be thus disrespected. For me, it's true that states' consent, states' will remain the foundation of international law and international courts, in particular their jurisdiction. As late Judge Ndaya put it, the jurisdiction of the International Court depends, he said it about the International Law of the Sea Tribunal, but it of course concerns all international courts depends in all instances on the prior consent of the parties, and no sovereign state can be party to a case before an international court unless it has consented thereto. States with this suspicious or sometimes hostile attitude towards international courts would consider the very initiation of judicial proceedings against them as an unfriendly or even hostile act. Today, we see some states even imposing restrictive measures on international judicial bodies and those who initiate proceedings therein. This situation is, of course, not black and white. One and the same state may be trustful to one international court and dislike another. It may refuse to appear in some proceedings and enthusiastically participate in others, even in the same court. A state may argue that there is no legal basis for a substantial part of a court's jurisdiction asserted by this court and still contribute to its budget. The attitude of a state to the courts or court may change over time. And there are of course, more nuances to be considered when one tries to assess states' attitude towards international courts. These mixed attitudes of states to international courts seems to be one of the reasons why so-called alternative dispute settlement means are being promoted. The recent adoption of the Convention on the Establishment of the Organization for Mediation is one of the examples. As I see it, for example, the treaty is permeated with the idea of respect of the parties, and that includes states, wills, and of non-imposition of neither the settlement process nor its result upon them. The adoption of the Convention follows a visible trend, both nationally and internationally, to promote mediation as a tool of friendly dispute settlement between both non-state and state entities. In this regard, I'd like to add that the fact that states have been more actively engaging international courts' advisory function may be pointing in the same direction. One may wonder if advisory opinions, though being judicially produced, could be considered, due to their non-binding character, as a kind of alternative to legally binding interstate dispute settlement. I'd like to conclude my remarks with another reference to the International Court of Justice. Its climate change advisory opinion states that international law has an important but ultimately limited role in resolving the problem of climate change. I wonder whether the same applies generally to international courts' role in the interstate dispute settlement. Thank you for your kind attention.
Judge Kolodkin, thank you very much. And now, Professor Miron, as an experienced academic and a practitioner as a consul, do you see any trends and challenges in interstate dispute settlement?
First of all, I would like to say hello to everybody in the room and to thank the International Center for the International and Comparative Law Research Center for the invitation. It is a pleasure to be here. It is also my first time in Singapore, and I'm glad to meet the friends from the center again in this context. I would, since I only have 10 minutes, I must say I'm going to speak about the same things as Judge Kolodkin with a different point of view, the point of view of the academic, who is a little bit more of an activist than the lawyers are supposed to be, and also from the point of view of a lawyer who is accompanying states in international litigation. But I do share some of the warning, I think, that Judge Kolodkin brought into his remarks. Well, I think, Igor, you set out the picture in the number of cases. Now we have, I think, I counted this morning, 25 pending cases before the International Court of Justice, interstate cases, of course. We also have some 7 pending interstate cases before the Permanent Court of Arbitration, acting as a registry, and we have 2 pending cases before ITLOS. So one might say that if we are comparing the situation with the one in the 1960s, 1970s, where the docket of the International Court of Justice was depressingly empty, one might say that the international justice and international litigation is in very good health, and we may, as lawyers, be very happy about it. The thing is, can international justice and international litigation be in very good health when the system, the multilateral system, is sick? And I think this says something about the system. The recourse to litigation, to international interstate litigation, says something about the system and the moment where we are in multilateralism. A number of these cases are related to ongoing armed conflicts. Other of these cases are related to violations of very important norms of international law, norms of jus cogens, such as genocide cases, genocide-related or allegations of genocide cases. So I think it says something about the moment of crisis, I think it's right to use the word, we are living in. And what can be the role of international courts and tribunals in this landscape? And I think the role is a little bit changing. We are witnessing a shift from a traditional bilateral dispute settlement where the court is an arbitrator between opposing views and is trying to find the middle ground, to a broader role of participation to international justice, and I think it's recourse to international courts helps us maintain the belief that there is a possibility of the rule of law at the international level. I don't think it's much, it may be seen as instrumentalization, and maybe that is the motivation of some states, but when we are looking at the result, meaning either the judgment or the advisory opinion, we are just seeing the courts going with this trend, and them asserting the law helps us maintaining the belief that there may be a rule of law at the international level. And the courts are really called to bring upon a legal clarity in this global turmoil, and I think it is important from this point of view, but they must do it within the limits of their jurisdiction, and I'm here referring to what Judge Kolodkin said, consent to litigation remains central to the system. And it is very important for courts to maintain this balance of proving that there has been consent to a case. And I think that on the overall, there may be exceptions, on the overall, courts manage to maintain this very rigorous analysis of consent. Some states may be unhappy about it, but what is important is really the attention that the courts have given to proving that there is consent. And I will show it through, if I manage to keep my time, through 3 examples. A very first one concerns the increase of what we are calling community interest cases, or erga omnes litigation. The second is what you mentioned, it's a big bang of interventions. And third, the role of advisory proceedings and how this interacts with the traditional role of dispute settlement. On the community interest cases, we do have now an important number of cases which relate not to a bilateral dispute between states, but to community interests, meaning to shared values. And what is interesting is the fact that we have an increasing number of cases introduced by states which are not directly affected by the situation at stake. I'm referring here to the genocide cases, the first one that has drawn the attention of the media, at least in the West, the one introduced by South Africa against Israel, but there has also been the case introduced by Gambia against Myanmar, both of them on the basis of the Genocide Convention, and the cases introduced against Syria by Canada, and the Netherlands on the basis of the torture conventions. So here we have states which are not directly affected, which are introducing a case. Is this lawfare, or is this a use of the international litigation system within the limits of jurisdiction for the purposes of advancing the rule of law of the international level? And I think the answer, let me again give the example. In the 1960s, where the docket of the ICJ was depressingly empty, it was empty because in the 1966, the International Court of Justice said that Liberia and Ethiopia did not have any interest to act against South Africa for its prolonged occupation, colonization of Namibia. And this this judgment of the court, okay, one may think that it respects very well state consent, but at the same time, it was seen as completely infamous, not only by African states, but by other states. And what happened is that the court has not received any cases for years and years after that. So now we are having, and these genocide cases are not the one that it's not the first time that the court accepted. The first time when the court accepted quite clearly the possibility of community interest cases is Belgium versus Senegal on the basis of the Torture Convention. And since then, more than 10 years, it has been quite clear that it is possible to bring such cases. Now, the interventions. Oh, the intervention, it's a big bang. And like every new thing, we have to learn how to deal with them. Interventions, we have two types of intervention at the international level, before the International Court of Justice. We have the interventions to defend a state's own rights and interests. This is what we call an Article 62 intervention under the statute of the International Court of Justice. So whenever there is a bilateral litigation and a state considers that its own right is at stake, right and interests are at stake, it may make an application to intervene. But this is not the kind of intervention that brought the Big Bang. It is what we call Article 63 interventions that brought the Big Bang. And the Article 63 intervention is states participating and bringing their view on the interpretation of a multilateral convention. Is it legitimate for states to bring their interpretation into a contentious case about a multilateral convention? Of course, it is legitimate because the interpretation given by the court would affect them one way or the other. The problem is not, and the statute provides for that. It's Article 63. We have it since the beginning of the Permanent Court of International Justice. The problem is that those interventions have been used massively in support of one of the parties, and that was done in Ukraine versus Russia. I don't recall if there were something like 23 or 24 interventions. And obviously, what happened there is that the political alliances have become legal alliances. And of course, that may be seen as a problem. However, the court had the solution to that. Well, more or less, at least in its case law, the solution brought by the court have been twofold for the moment. First, to try to maintain the equality between the parties, and this is particularly important because if you have 24 states siding with one of the parties, in terms of timing, in terms of documents to analyze, it of course affects the equality of the parties. So the court brought some kind of solution, not perfect, but tried to bring some kind of solution to that. And second, I think, but something which is ongoing still, the court is trying to order a little bit the interventions and to align them with the purpose of intervention. The purpose of intervention under Article 63 is not to side with one of the parties, is to interpret the law. And there is something else. I think the world is watching how the states bringing interventions are reacting to these diverse cases. And we have states which have introduced interventions under Ukraine versus Russia, and also in other cases, in the Gambia versus Myanmar. And so the coherence of their interpretation, I think, is going to be watched not only by the legal academics, but also by others. A last point, I won't speak about advisory proceedings, just a last element. I'm looking at the participation of the proceedings in general. And what we have seen, so it's a broadening of the participation through the interventions and through the community interest cases. However, there is little participation from states from Asia. There is none which has introduced a case, and quite interestingly, there is no intervention in Gambia versus Myanmar. And I think we have to ask ourselves why. There is more participation to advisory proceedings, but almost none in contentious proceedings like that. Thank you very much.
Professor Meron, thank you so much. And if I may, just one question to both of you, Judge Kolodkin and Professor Meron. You both, in your presentations, referred to the increasing number of interventions as well as the more frequent usage of the advisory function to address some situations which in fact represent a dispute. And you also mentioned that it is referred to sometimes as a lawfare with a negative connotation to that. But we also, at the same time, we see how and you mentioned that as well, we see how international cooperation can be important. For example, with respect to such issues as the climate change or pollution by plastic. But what we also see is that traditional forms of international cooperations may not be efficient sometimes. So the question is, do you think international courts represent a beacon of hope in the face of sometimes ineffective multilateralism? Judge Kolodkin, maybe you, if I may.
Yeah, a hope, definitely. But a hope is a hope. I mean, it's not a substitution of the decision-making. Once again, I think I was thinking about a different thing raised by Professor Meron, but anyway. I mean, courts cannot substitute it. They may help, of course, clarifying issues of international law, but very much depends on how these clarifications, these legal pronouncements of international courts are received by states. I mean, even after this streak of advisory opinions on climate change, which is absolutely multilateral, international community, communitarian, public interest things. After the streak of the advisory opinions, and something tells me that the fourth advisory opinion, which is now before the African Court of African Regional Court, will be consistent with the advisory opinions of the ICJ, Inter-American Court, and our tribunal. Even after that, how states will receive the major pronouncements contained in this streak of advisory opinions? Ultimately, the authoritative interpretation of multilateral international treaties are in the hands of states parties. And besides law, there's so many interests involved. So yes, courts help, but they cannot substitute major actors. That's how I see it. Sometimes even there may be something not very good, let me simplify the language, not very good about judicial action. I started with the Judge Nolte's declaration. It's also, like Alina said, it's also a kind of warning. Many people now see these pronouncements of ICJ and ITLAS, for example, in their advisory opinions, as a kind of invitation to litigate the responsibility, the compensation issues concerning climate change. I wonder if, following Judge Nolte, if the opinions are used like this, whether it wouldn't be detrimental to the process, negotiation process, where multilateral solutions are being sought for this problem. And one more thing, if I may. I mean, proceedings in the courts are changing, of course, we see it, but they are changing following the change of the system, the international system, and following the change of international law as such, material international law. Once the system and the international law started to protect common values, common interests, once we started to have obligations erga omnes or erga omnes partes, then of course the courts are following inevitably, I think, and judicial action started to seek protection of these values and interests embodied in the rules of international law. So it's a kind of inevitable change, as I see it. Thank you.
Just to say first that, like you, I am not very happy with the use of the word lawfare. It may sound attractive, but there is a parallel with warfare. And honestly, appealing to the rule of law, to the international legal rules, this is not war. It is the opposite of war. And it's a word which is trendy now, but it just reflects something that has always existed. States have a policy, a judicial policy, meaning, and this is part of international relations and has been part of international relations forever, meaning that they would have a particular interpretation of international law, and they will have a particular use of the international institutions. So this is just judicial policy, and it depends how you use it. Now, of course, one may see a risk of instrumentalization, but the thing is, it's not the motivation of states that matters. It is how the decision comes out and how the courts protect the integrity of their judicial function in this changing landscape. This is what we have to look at. And I think this is particularly important to show that courts remain within the bounds of their competence and of their judicial function. And are they a beacon of hope? Well, the world is what it is, so we have just to take it and try to, well, first to have an analysis of what's happening, and it's true that it's not very encouraging what we are seeing, but also to have an idea how we can use the international institutions. And we mustn't focus just on the political institution. Judicial institutions are part of the framework and what can be their role. Looking at the advisory proceedings, what matters is, of course, is the balance that is kept and the fact that the courts are not bypassing the judicial function, meaning that they do not become the authors of the law. They are not engaging upon a legislative function, which they do not have. Of course, at balance, when you have an international law which is not always crystal clear, by interpreting, you may go a little bit further than one may think that the law stated at some point in time. But law is dynamic, and international courts are participating to these dynamics. What matters in the end is, because the advisory proceedings are not binding, is what states are going to do with the advisory proceedings. and take two examples. What the International Court of Justice said in the cases concerning the occupied Palestinian territory. Of course, it is all the obligations for Israel, but there are also obligations for third states, meaning the obligation not to recognize the lawfulness of the occupation, meaning also that there are duties not to entertain investment and commercial relations in relation to the occupied territory and so on. We have heard very little about this statement of the court, and this statement of the court is not a new one. For climate change, let's see what's happening, but I think even among the developed states, some are very happy with the way the court responded on the obligations of states under the climate change treaties and the interaction with the customary international law. In particular, when you have states such as the United States, which are withdrawing from the multilateral treaties. So I think the way the advisory opinion will be used in the ongoing negotiations, I think it will be a sign of the importance of the court, and I think there is a lot to be used in that opinion.
Thank you so much to both of you, Judge Kolodkin and Professor Meron. Let us now proceed to investor-state dispute settlement, something that is probably more known to the most of the audience in the room. The legal framework for ISDS has been significantly developing since 1960s, when provisions for investor-state dispute mechanisms, as we know them, began to appear in bilateral investment treaties. In 1966, we also know that the ICSID Convention was adopted and entered into force, providing for the institution that would provide also facilities for conciliation and arbitration, as well as more recently for mediation of investor-state disputes. In the last decade, however, investor-state dispute settlement system has been under serious scrutiny, and the international community has been looking into the needs of the possible reforms of the ISDS system. One of the most prominent forums where possibilities of reforms are discussed is the Working Group 3 of UNCITRAL. And Mr. Ong, given your experience with the ISDS as a governmental official, and especially your active participation in the work of the Working Group 3 of UNCITRAL, we would very much appreciate if you could share your views and thoughts on the current trends and challenges in the ISDS, and also tell us more about the ongoing discussions of the reform at the UNCITRAL.
Thank you very much, Mr. Fedorov. I think I need the clicker. That's right. Thank you very much. Well, as Mr. Fedorov has already foreshadowed, we are now pivoting away from interstate disputes to investor versus state disputes. And thank you very much also, Mr. Fedorov, for setting part of the context, but noting that we do have a diverse audience today, at least a good segment of which are possibly more public international law focused than ISDS focused. I think I will cover three areas. First, and especially for those who are new to this area, I will walk through some of the key statistics and trends on ISDS. This is to set the context. Then, against that backdrop, I will describe the main criticisms and concerns that have been leveled against ISDS, and which was alluded to by Mr. Fedorov in his remarks just a while ago. Finally, I will cover the where next part of the discussion and look at some of the recent and ongoing ISDS reform efforts, including those at UNCITRAL. So let's start with the big headline numbers. The World Investment Report 2025 edition, which was published by UNCTAD just 2 months ago in June, records that as at the end of 2024, there have now been about 1,400 ISDS cases. Now compare that with the 230 plus cases on the ICJ docket over an illustrious history of 80 years. This is at least 5 times as active in 5 times as short a time as the ICJ. So I think there's a lot of public awareness and a lot of scrutiny over this area, partly because of the caseload. And you can see that, in particular, the explosion of caseload really took off or took place from about 20 years ago in the mid-2000s. and reaching a high of more than 80 cases, or is it 60 cases a year in the years 2015 to 2018. And then these are the top users of the system. On the left, you have the top 15 respondent states together. They make up 646 of those 1,400 cases, which means that it's about just slightly less than half of all the ISDS caseload involves one of these 15 respondent countries. And then on the right-hand side, you have the top 15 nationalities of claimant investors. And they account for more than 1,100 cases, which actually is 80% of all the cases. And you can see that it is also a little bit more disproportionate in the sense that some of the bars right at the top of the chart are a lot longer than everything else. And you can see these are where all the investors tend to hail from. Now, what about who wins and who loses? Contrary to popular belief, actually, states have tended overall to fare slightly better than investors. As you can see on the chart, roughly 38% of the cases have been resolved in favor of the state. And this is, of course, counting the cases in which the state prevailed at the jurisdictional objections phase. This is compared to 28% of cases that were resolved in favor of the investor. Next, sizes. Again, in the World Investment Report 2025, it noted that both the mean and median values of claims and awards have been trending upwards over the past 10 years. So if you look at the lighter blue colored lines, those are the past 10 years, and you compare that with the darker blue ones, which are for the preceding period of about, I think, 20 or 25 years, you will see that the average claim amounts are now hovering at close to the $1 billion mark for the average claimed amount, and then for the average awarded amount, that's about $230 million for each case. And these are the top 10 ISDS awards that have been rendered in all time. And you can see that even at the number 10 position, it's hovering well above the $1 billion mark. Next, costs. From this, you'd see that expectedly, the larger the amount in dispute, the higher the costs. But interestingly, from the blue bars, you can see that the investors have tended to pay more for their legal fees as compared to states, which are the ones reflected in the dark red or dark brown maroon bars. So on average, states paid $4.7 million for legal costs, whereas claimants paid on average $6.4 million. Finally, duration. Again, expectedly, the bigger the claim, the longer the duration. And the global average stands currently at 4.4 years, although the mean is 3.8 years. So now, against the backdrop of the trends and statistics that you saw on the previous few slides, here are some of the criticisms that have been leveled against ISDS, particularly during the last 10 period, the period of the last 10 years when this backlash started to really reach a crescendo. First, lack of coherence and predictability. And actually, as Judge Kolodkin mentioned earlier, in contrast to international judicial bodies, courts, where there is a certain sense of stability, predictability in the jurisprudence, if we can call it that, I think the opposite is true. In an arbitration, in an ad hoc scenario, there is no jurisprudence as such. So disputing parties frequently end up relitigating every single issue and every single treaty provision afresh from one case to another. And as a poster child, right, for everything that's wrong about ICS, of course, this is one case. Everyone would know about the CME and Lauder cases versus the Czech Republic, where there were two cases involving essentially the same facts, but involving two different treaties, although the provisions were materially identical to each other. But you had two directly contradictory outcomes in these two cases, and then that's become kind of the poster child for everything that's wrong with ISDS and the lack of coherence and predictability. Next, you have the concerns about arbitrator independence and impartiality. Again, because of the ad hoc nature, I think we give rise to the perception that some arbitrators are seen to be very pro-investor and others are pro-state, and then this gives rise to the possibility or the phenomenon of disputing parties possibly going arbitrator shopping when they're doing their party appointments. Arbitrators double hatting as counsel, and also the emergence of third-party funding have also recently been cited as risk factors that affect the issue of impartiality and bias. And finally, the issue of diversity, which is compounded by the phenomenon that I just described. I read somewhere in a recent article a few years back about the phenomenon of the pale, stale, and male set of very limited arbitrator pool, and with no offense intended to any. I don't think anyone here falls in that category, but I think you get the idea that there is, in fact, a remarkable lack of diversity and geographical distribution in arbitrator appointments. And finally, partly because of these two different areas of concern, you have this situation of high cost and duration, because you have parties constantly relitigating the cases and making and spending more and more and longer on their cases because of the perceived inadequacies of the system. Now, so in an effort to address such criticisms and concerns, what are some of the recent and ongoing ISDS reforms? First, we have the ICSID Rules Amendment Project. This process began in 2016, involving multiple rounds of consultations with all the ICSID member states, and it culminated in the new rules of 2022, including not just the revamped arbitration rules 2022, but also completely new sets of rules like the mediation rules and the fact-finding rules. Some of the key features are what you see on the screen, but there's expedited arbitration, disclosure for third-party funding, a new dedicated rule that fleshes out and clarifies the summary dismissal process for cases that manifestly lack legal merit, and the newer and updated rules on costs and on time limits. The problem, though, is that ICSID rules reform naturally is limited to what can be done within the four corners of the ICSID Convention, and of course involves mainly the member states. So there has been a much broader ranging ISDS reform project under the auspices of UNCITRAL that's been going on now for the last 8 years. Working Group 3 has been working on this since 2017 under the three-step process that you can see on the screen. And because Working Group 3 is not limited to any particular governing treaty regime, unlike ICSID, it is in a position to explore a much broader spectrum of reform options. So these range from what are called the incremental reforms to improve on certain aspects of the existing system, through to slightly more ambitious structural reforms like the possibility of developing an appellate mechanism, all the way through to deeper structural reform, such as developing a multilateral investment tribunal to replace the ad hoc system. Naturally, UN delegations have diverse positions on all of these issues and have different levels of ambition, and so they fall, at different places along the spectrum, as you can see by way of example at the bottom of the screen. Now, here's a status report of what's gone on at UNCITRAL Working Group 3. Over the past 3 years, the lower hanging fruits, as I would like to call them, have already been harvested. So these would be the codes of conduct, mediation model rules, a statute on the advisory center, and then this leaves the bigger substantive packages where work is still ongoing, and those are the ones highlighted in yellow. The first of those you see is a package of procedural rules, and these include provisions like security for costs, manifest lack of legal merit, third-party funding disclosure, time limits, etc., and also non-disputing treaty party submissions. These are the kinds of rules that we're trying to do to align them with the 2022 ICSID rules so that there is less fragmentation and there's more harmonization between the ICSID rules and rules for non-ICSID arbitrations. But there are some issues in this package that are more controversial, things like assessment of damages, right to regulate. So more time will be needed to start reaching a landing zone on even the procedural rules. Then you also have the ongoing discussion on the structural proposals, like establishing a standing mechanism, either for first instance cases or for appeals or for both. And these are some of the things that are going on right now in the ongoing discussions, including the one upcoming in September at UNCITRAL. What kind of design to give a single instance mechanism or an appellate mechanism, or do you want to create a mechanism with 2 tiers? And so discussion goes on that because the design, these are big design questions that do need to be answered before we can actually begin to crystallize concrete products and brick and mortar, of course. And then to tie all of this together, we do need what is called a delivery platform, which is called the Multilateral Instrument to Implement ISDS Reform, or the MIR for short. And if you want to kind of get a sense as to what it does, I like to think of this as kind of like an operating system for a smartphone, so like an iOS or an Android, where you need that as the base, and then you have all these little plugins and different apps that you can decide to subscribe to or download, depending on your interest areas as to what do you like WhatsApp? Do you like LinkedIn? Do you not want to have LinkedIn and have Facebook instead, et cetera, and then you kind of have this whole menu of different possible options that you can choose to then download onto your iOS. And with that, thank you very much for your attention.
Thank you very much, Mr. Ong, for enlightening us. And I now turn to Mr. Xavier. Mr. Xavier, you have a significant practical experience in both commercial and investment arbitration as arbitrator as well as a consul. And would you please share your views on the trends and challenges in these areas? Do you think there are any lessons that could be employed from the commercial arbitration to ISDS and vice versa? Mr. Xavier, the floor is yours.
I think, a number of the things that I could talk about, Chin Heng has laid the platform for. I think if you summarize the biggest problem in the, and many of you here are practitioners, you would appreciate and you would agree that the biggest problem I think faced by the ISDS terrain today is the high degree of uncertainty that permeates the entire infrastructure. So, one of the things is the proliferation of types of the forms that ISDS takes, right? According to an UNCTAD report that that you would all be familiar with, 71% of ISDS takes the form of ICSID arbitration. 21% take the form of ad hoc UNCITRAL, supervised by the PCA. And then the balance, about 8% odd, is now spreading across Stockholm, LCIA, SIAC, and all the ICC, the other international commercial arbitration platforms, right? And as time goes on, the perception is that a lot of the newer cases are going into a fair amount into the commercial arbitration platforms, institutional platforms. Now, this is not very helpful in the sense that there's a greater, I think, permeation of this uncertainty. And one of the things that Chin Heng spoke about, which is the fragmentation of decisions, right? So Chin Heng spoke about the same treaty clause, which is adopted across different treaties, in different treaties being construed by different tribunals. But you have that problem with the same treaty provision being treated or construed by the same type of tribunal, maybe not the same tribunal, but say an ICSID tribunal in a different case, and they come up with a completely different decision. I mean, you will see, international law is replete with examples of that. I'll just give you one. 2000 financial crisis, Argentina had a BIT, US 1991, Argentina, US BIT. It introduced a number of economic measures within Argentina, and a lot of US businesses were hit. And so Argentina was taken to a series of ISDS actions, 5 in particular. And in these 5, I'm just saying 5 because in these 5, the essential security clause, the same clause in that one treaty was under discussion. And in one ICSID case, the gas transmission case, the tribunal found against Argentina, saying that the crisis was not enough for it to rely on the essential security clause. And subsequently, in another ICSID panel, the Continental Casualty case, that case found, and it's very interesting because you get different arbitrators. There's no permanent court, which we are trying to fix. But I think, I think the consensus is it'll take a long time to fix it because the number of underlying, cogs that needs to be fixed, it's very hard to get consensus, but we hope it'll be fixed. So, so in the Continental Casualty case, that particular tribunal placed greater emphasis on trade law principles rather than customary international law principles, and came to a diametrically opposed, and saying Argentina could rely on the essential security clause. So this is crazy, right? So at a day, when you have ICSID tribunals ruling on the same provision in the same treaty differently, completely differently, like they're on two different planets. And then what you're seeing on the ground is you're seeing a proliferation of platforms. International commercial arbitration platforms being used for ISDS. And so this uncertainty is sort of increasing. Now, and then you have the challenge of so one of the challenges, for instance, in the choice of forum is, ICSID, all of you know ICSID is opening its office which is a good thing, in Singapore. So now we Asians can say they're giving us face, and they have an Asian face, so maybe they're not Ang Mo after all, they are also Asian, because they have an office in Singapore. But, the thing is this, right? So I think what the world needs is a coherent approach to major standards, FET, MFN, blah, blah, blah. So coming back to fragmentation, you've seen how elements of FET, fair and equitable treatment, are treated completely differently by different tribunals, right? What are the elements? What is the emphasis? So that doesn't help, right? Even if you have coherence of platforms, you get different decisions. So I think what is essential is, and one of the things that, we need to keep talking about with ICSID is that there needs to be some kind of, a best practices guide to interpreting common standards. We like to believe that these standards are fairly common, anti-expropriation standards and all that. There should be a basic understanding across the globe. So I think that's something that the international community needs to work on. And this problem is compounded in Asia, let's say, by, I don't know whether you alluded to it, Chin Hing, but this backlash, which started in about 2010, 2014, right? So you have the stars of the backlash in Asia, at least, leaving aside South America. You have Indonesia, Australia, India being very vocal. I see some people from India. So India in 2014, after the white industry case, I mean, you guys will be very familiar with this, exited 75 BITs. And since 2014, it issued its 2016 code, its own code, right, as to what should be the international standard for all these. So it's India's perception of what the international standards for protection should be, codified in its own promulgated 2016 model code, right? And since then, India has only entered into 4 BITs with those provisions. Very limited definitions of investor and investment, huge carve-outs. I'm looking at it from the point of view of the investor. Huge carve-outs being exempted, and strict preconditions, right? Exhaustion of local remedies. You need 3 or 5 year windows before you can even take out a suit. Mandatory mediation, which is not a bad thing, I suppose, conciliation and all that, making it very hard for the investor to take action, essentially, right? And then you see that also mirrored by Indonesia. It had 67, it exited 25 post 2014, and has only entered into, I think, 3, again, very restrictive worded BITs after 2014, one of them with Singapore. I guess Singapore, being a member ASEAN state, had to agree to those terms. Sorry, I'm not saying anything about your negotiations of MTI. And then Australia, in 2022, made it very clear, no more ISDS provisions. And since then, well, of course, the problem started in 2015 with the Philip Morris case. The only BIT that it's entered into is last year, but it's not come into force with UAE. No ISDS provisions, right? And that's replayed over RCEP, right? The largest in terms of population, GDP, and trade numbers, the largest FTA in the world, the Regional Comprehensive Economic Partnership, 10 ASEAN states, and Australia, New Zealand, China, Japan, and South Korea, right? No ISDS provisions. Yes, there is, Chapter 19 has a panel binding decision which you can get, but that panel binding decision can't be enforced under ICSID Convention, can't be enforced under the 1958 New York Convention. God knows how you can enforce it. So it's just going to be a piece of paper that says I'm binding, but you can't do anything about it. So no ISDS provisions in the largest FTA in the world today, came into force January 2022. So it's a very unsatisfactory state of affairs. And if we get a permanent court, standing court soon, that will solve a lot of these problems, but we're not going to get it soon. And because of that and other issues with arbitrator gaming, there's a sense that arbitrators are being appointed, party-nominated arbitrators used to game the panel. There is a drive towards, I'm going to hand it back to you, Igor, in terms of time. A lot of business is going to, international commercial courts, so no surprise that they're mushrooming all over the world. Back to you, Igor.
Thank you so much, Mr. Xavier, and thank you very much for looking after the time and doing part of my job as well. But I do have one question for both of you, Mr. Ong and Mr. Xavier. You mentioned in your presentations certain concerns and criticisms which are relevant to a big extent to ISDS, but also to a certain extent in commercial arbitration. You also mentioned some transformation processes going on in both, and with the ongoing reform of ISDS, it feels like there might be a greater state control over ISDS to a certain extent. We may also see a general institutionalization of arbitration and formalization of process. And to a certain extent, one could possibly conclude that arbitration begins to resemble more and more national courts. At the same time, business actors, they do value confidentiality, they value other traditional features of arbitration. They wish to have more control over the formation of the tribunals. And those are among the reasons why ISDS and commercial arbitrations have been favored so much in the last decades. So do you think if the ongoing transformation processes to a certain extent may eventually deter business from using this means of dispute settlement?
I will try to keep it short, but my one word is ultimately we all need to strike a balance. So the word balance would be my single word answer if I had only 30 seconds to answer. But if you can indulge me for another minute or two, I think basically what Mr. Fedorov says is correct in that as there's greater judicialization of ISDS, if say the European Union, right, which is the chief proponent of the multilateral investment tribunal, if the European Union were to get its way, then there would be an MIT with a first instance court followed by an appellate layer. That is precisely what is sought to be created, to create an international court that looks at investment disputes, and with an appellate layer, kind of like the WTO, although I'm sure that's not a very good example to use right now. The appellate body in the WTO is not working, but that was the original motivation and the original inspiration. Of course, in developing such a reform solution, we need to be conscious of all the different missteps or issues that have been plaguing other judicial institutions along the way, and course correct and try to preempt and not fall into the same traps. And that would be my slightly longer answer. I hope I've answered the question.
I think I'll stay away from the WTO. I saw when you mentioned WTO, Professor Miron had a chuckle. The WTO process, is irretrievably broken at the moment. I can't see how it's going to be fixed, so I'm going to stay clear of that. But I think until we hit we are Alice in Wonderland, we reach Wonderland, and there's this permanent court, UNCITRAL Working 3 actually succeeds. I think the one solution, and I think not enough is being paid. I think we need to, as a community, so in order to engender more certainty, I think as a community, we need to, in the absence of a permanent standing court, I think we need to stick to ICSID. Right now, you know, the numbers that UNCTAD are releasing is not 71% ICSID. It's not reliable because a lot of the ad hoc ancestral arbitrations that don't go through the PCA are not recorded, right? They may not be institutional, right? And so we don't have the clear numbers, especially in Asia. So I think the real solution is, I think we should all, you know, states and investors should stick to ICSID. ICSID is well-oiled. Its rules are tailor-made for investor-state, not, you know, to disputes between private commercial parties, right? It takes into account public interest, interests more than private interests in the way that, you know, SIAC rules or Stockholm rules, yes, they've all come out with, and I hope there's no representative of these arbitral institutions here. It's not impolitic to say this, but, you know, I mean, ICSID rules are fit for purpose, investor state, right? It's well all now. Some people, so I think what is people don't realize is, you know, there's a big debate in the international space about how contractual disputes can be brought within a treaty, right? So you're acting for a client who has a contract with a state arm, and then you're trying to figure out, there's a treaty, and maybe I'm going to bring the suit, you know, under the treaty. But what people, counsel and corporate players forget is that you can just have a regular plain vanilla contract with a state or a state arm with an ICSID clause, and then you go within ICSID. You don't need a treaty for that, right? And of course, some of you will say, yeah, but how does that work? You know, if I go to ICSID in the absence of a BIT, and ICSID arbitration is seatless, but that's actually an advantage, because when you have a seat, you have problems, right? Because then you have a seat court that you're worried about, right? Now, some seats you have confidence in, but some seats you don't, right? You have all these courts setting aside, so you avoid the seats. There's just one stop to set aside, annulment committee, which is difficult. You know it's difficult, right? And then the ICSID, yeah, hopefully ICSID will come up with some kind of a best practice on interpreting certain standard clauses and not have one ICSID tribunal A saying this and ICSID tribunal B saying that. That's something we need to fix. But at least you'll have more certainty. Back to you.
Thank you so much. And I think it well brings us to the something that we haven't discussed so far, and that's the mediation as such and the role of mediation in resolution of international disputes involving different actors. And thanks to the efforts of Singapore and its representatives in the relevant working groups of UNCITRAL, we now have the Singapore Convention on Mediation. But more recently, we also saw the adoption of the Convention on the establishment of the International Organization for Mediation, or the Hong Kong Convention. And Ms. G, I understand that you were actively involved in the drafting of that convention, and you are now working in the preparatory office of the International Organization for Mediation, or IOMID. So we would very much appreciate if you could enlighten us more about this newly, or soon probably to be established organization. And if you could also tell us if there is any link or interplay between the Singapore Convention on Mediation and the Hong Kong Convention. The floor is yours.
Thank you, Igor, for your kind introduction. Good afternoon, everyone. It's great to be here in Singapore, especially during the Singapore Convention Week, with such a diverse group of colleagues to discuss the emerging trend and inspire collaboration in international dispute resolution. Today, I will share the most exciting development in recent years, the creation of the International Organization for Mediation, the IOMAD. It is the first treaty-based intergovernmental organization dedicated solely to mediation. The idea came about in 2022 when China and a group of like-minded countries decided to jointly initiate the IOMAD to meet the growing demand and fill an institutional gap in mediation. If you look at the global dispute resolution landscape, you may find for adjudication we have ICJ, ILAS, ICC, etc. For arbitration, we have ICSID, PCA. Yeah, for mediation, no global intergovernmental platform where mediation is the main service, not just an add-on. Historically, mediation is among the oldest and most flexible method for dispute settlement. In interstate dispute settlement, mediation as well as conciliation plays an important role and has been stipulated in numerous bilateral and multilateral treaties such as the 1899, 1907 Hague Conventions, the UN Charters, etc. And in investment mediation sphere, UNCITRAL has carried out lots of work on that with the aim of encouraging the use of mediation for resolving international investment disputes, such as the model provision and guidelines on mediation. For international commercial mediation, a milestone achievement is the Singapore Convention on Mediation, which provide an enforceability framework and give mediation royalties at the enforcement stage. And the Singapore Convention and the LMAD, I believe, are mutually reinforcing. While the Singapore Convention provide a legal backbone for cross-border enforcement, the LMAD aims to strengthen the availability and quality of mediation itself by offering an institutional platform for it. Together, they will contribute to the use of mediation as a first choice dispute resolution method. And also in drafting the LMAD convention also its mediation rules, we also factor in the requirements of the Singapore Convention and try to make the settlement agreement reached under the LMAD meets the requirements of the Singapore Convention to make best use of it. And also nowadays, mediation is gaining more attention, popularity, and demand, giving its many outstanding quality that comes into light. Mediation stands out as a flexible, economic, and also efficient, not that 4 years long, means to narrow down or even resolve the difference between parties, especially when they deeply value voluntariness, party autonomy, confidentiality in the process, creativity in the settlement terms, as well as preservation of long-term relations and a business interest. The LMAD is built on this momentum and the vast unmet need. You may also ask, with so many mediation institutions established recently, why create an intergovernmental organization for mediation? We've answered these questions in many occasions and have summarized it in 5 C's. The first is a commitment. The LMAD represents a strong political view and a government-level support for mediation, which can encourage its use both nationally and internationally. The second is convention. The LMAD Convention is the first global convention that formulates the fundamental principles and rules concerning international mediation, such as voluntariness, confidentiality, avoiding of conflict of interest, etc., to foster the harmonization and development of international mediation law. Third is credibility. As a state-backed intergovernmental organization, the LMAD ensures neutrality, independence, and authority, offering reliable dispute resolution method. The fourth is capability. The LMAD will assemble panels of top-tier mediators with expertise, reputation, integrity. These mediators designated by the member states of the LMAD and coming from diverse domains can ensure the quality and outcomes of the mediation. Fifth is the collaboration. The LMAD will enhance the global mediation ecosystems by collaborating with international organizations, governments, sharing best practices, and organizing capacity building activities. It aims to increase mediation awareness and expand the pool of skilled mediators. With this shared vision and clear value proposition, the next was turn the idea into reality. In February 2023, the LMAD Preparatory Office was set up in Hong Kong, XAR, China, and mandated to organize and coordinate intergovernmental negotiations on the ALMAT Convention. Over 20 months, we hosted 5 rounds of negotiations, and in October 2024, we successfully concluded the convention, and just this May, 33 states signed the convention at the signing ceremony held in Hong Kong, SAR, where the ALMAT will be headquartered. As of now, there have been 34 signatory states to the convention. And here I'm also pleased to share the good news that the ALMAT Convention will enter into force tomorrow, following the ratification by China, Nicaragua, and Venezuela. I believe there will be more countries ratifying the convention in the near future. Here I will also highlight some main features of the convention. The convention, also known as the Hong Kong Convention on ALMAT, comprising 11 chapters and 63 articles. You may also find the whole text of the convention on the official website of the ALMAT. The convention sets out the legal and institutional framework for the operation of the ALMAT. The ALMAT's scope of cases is broad, covering disputes between states, commercial investment disputes between a state and national of another state, international commercial disputes between private parties. And party autonomy is at the heart of the ALMAT's mediation service. Mediation conducted under the ALMAT shall only proceed with the consent of all parties to the dispute, and a state when joining the ALMAT may, by declaration, exclude certain categories of disputes. And if disputes involving the third state, its prior consent is required before the commencement of the dispute. And also, the ALMAT will maintain its own panels of mediators, the panel of state-to-state mediators for interstate disputes, and the general panel of mediators for commercial investment disputes. And member state to the ALMAT is entitled to designate certain number of persons to those panels from among their nationals. And the governing council, which is the decision-making body of the ALMAT, is also entitled to designate certain number of persons to serve on the panels who may not be from member states, giving due regard to the representation of major legal systems, geographical diversity, and gender balance. The ALMAT will also adopt its own mediation rules, the state-to-state mediation rules, the international investment and commercial mediation rules, and I will not go into details due to the time limit. And we know that building an intergovernmental organization from ground up is no small task, and much remains to be done from the ALMAT governance rules, mediation rules, to preparing the opening of the organization, to promoting the ALMAT and the convention. And it is expected that the ALMAT will be formally established and coming into operation in the second half of this year. And our office will continue to act as the interim secretariat of the ALMAT to advance its work. And also here, we also warmly invite more partners to join us in building this new institution. Yes, and a global public good dedicated to amicable dispute resolution, contributing to a more harmonious, stable, and sustainable international order. Thank you for your attention.
Ms. Ji, thank you very much for your presentation. You described well the advantages of mediation, and one of the advantages, as you mentioned, is the confidentiality, as mediation is designed to be confidential. But at the same time, as we heard from some of our panelists, even though there is a growing interest to mediation, at the same time, there is, with respect at least to interstate and investor-state disputes, there is an ever-growing public scrutiny and an issue of transparency with respect to, in relation to such disputes. So in this regard, do you think that recourse to mediation, at least in interstate and investor-state disputes in particular, may confront once again with public criticism or pressure for the lack of transparency? And if so, what are the possible means that the international community as a whole and then states individually should take in order to keep the mediation attractive?
Thank you, Igor. That's indeed very important and thought-provoking question. It is true that mediation by its very nature relies heavily on confidentiality. Confidentiality is what allows the parties really lower their guard to speak frankly, to explore solutions in a way that they may not feel comfortable in discussing in litigation or arbitration, especially issues as sensitive or delicate. Without mediation, without confidentiality, mediation may not work as well as effectively. At the same time, we cannot ignore that, especially in investor-state dispute resolution, there's a legitimate public interest and increasing demand for transparency. So there's a natural tension here, how to preserve the advantages of mediation while responding to the transparency concerns. I personally do not think the mediation will face the same legitimacy crisis as that ISDS has faced, especially for interstate mediation. In most occasions, for interstate mediation or conciliation, lots of information or documents relating to the interstate mediation cases made public by the governments or mediators, conciliators, or the case management institutions. And such, for example, the latest one is the conciliation between Australia and Timor-Leste on the maritime delimitation, and such other cases, such as the Indus River mediation between Pakistan, India, and also the Yamayan conciliation case between Iceland, Norway, and also the mediation on the dissemination of assets in the former African community between. It's just, you may find lots of informations on the website, but the investor state mediation is another story. Very rare information can be found. So now with that, we also need to be mindful that to the transparency and confidentiality issues. A few things are important in my mind in this regard. First is the confidentiality should confidentiality should remain principle in mediation with some carefully designed exceptions. This is the common practice in some mediation rules developed by many institutions such as UNCITRAL, ICSID, IBA, WIPO, maybe. The exceptions may vary under different mediation rules. It may include disclosure of information required by law, enforcing the mediated settlement agreement under applicable law, or the document or information is already in public domain, or in situations of serious crime or maybe public safety concerns, etc. The LMAD also adopt this same approach, recognizing confidentiality as a general obligation with some exceptions to it. So this way, confidentiality can be protected, while some spaces is also left to respond to the legitimate transparency requirements. My second point is that we need to ensure adequate flexibility and a margin of discretion for states in the mediation, especially the transparency requirements are mainly a matter of domestic considerations if there's no conventional customary international law on that. And there isn't really a one-size-fits-all degree of transparency in mediation. It varies depending on the disputing states, the subject matter of disputes, the goal of the process, the degree of public scrutiny of around the case, or even the stage of the case. And also, party autonomy is paramount in the whole process of mediation, and also in addressing confidentiality issues. States may decide for themselves on how to arrange their transparency obligations in specific cases in a way that can fit their national interest while still meeting their public scrutiny needs. For example, such as the disputing parties or disputing states or parties can reach agreement before the commencement of or during or after the mediation proceedings to make to public some or all the information document relating to the mediation proceedings, or as well as its outcomes. And also for the LMAD, its mediation rules, though it's still in the making, will also provide the disputing states with a high degree of discretion to design the mediation process that can best fit their needs and meet the domestic requirements and transparency obligations for the oversight. My last point is that well-developed institutional safeguard may also play an effective role. The LMAD, as the first intergovernmental organization dedicated to mediation, is designed to provide institutional support, case management, as well as a certain degree of oversight of the process. So, also, in addition to the principle of voluntariness, the LMAD Convention also sets out some fundamental principles like voluntariness, impartiality, and good faith, which can help build trust and public confidence in the process. And I also believe over years, by handling more and more cases, mediation cases, the LMAD can also serve as a suitable platform to explore best practices on how to balance confidentiality and transparency. So my answer to your question is the same as Mr. Ong. It's a balance that the mediation should remain confidential as a rule, but it must also be adaptable enough to respond to today's call for transparency. If we get this balance right, mediation will not only avoid the legitimacy crisis, but also become even more attractive as a trusted way to resolve differences. Thank you.
I don't know if I should abuse any more the position of moderator, asking more questions. I do have more questions, to be honest, that I would like to ask, but let us take on questions now from the audience. I think that would be a proper time for it. Yes, please. Can we help with the...
Oh, there is a row of hands.
Sorry, age before beauty. Well, thank you to the panel. My name is Herman Jeremiah, and as Mr. Ong, my question is for you. As you were going through the list of things which the working group 3 is trying to sort out, you then mentioned in passing the assessment of damages, right? To me, that is critical because a lot of the criticisms that ISDS has been seeing is the high awards awarded against states and the use of the DCF method for a project which has not taken off. I mean, the Tatian Copper against Pakistan case was one example when the project never took off, but they applied not just the DCF, discounted cash flow method, but a modern DCF method, all right? Now, the DCF method is actually intended for a situation where there's a past record that you can actually have in terms of revenue, and then you extrapolate, all right? So for a project that's not taken off, right, the DCF method is questionable as a method. And you actually have some tribunals who have actually stayed away from the DCF method and come to an award which is more reasonable. But you said that that was a controversial issue, and therefore the working group 3 is staying away from it. I'm not entirely sure that that's the right answer, because my personal view is that you can solve a lot of problems, this so-called legitimacy crisis of the ICS, if you actually deal with that problem. Some years ago, the UNCITRAL working group, one of the working groups came up with some notes on assessment of damages, and one of the recommendations was don't use the DCF method for a project that's not taken off. And the accounting, the valuation experts would be able to tell you that there are other methods, there's comparable market and all that, and you put to, and tribunals have actually made that work. So I think it's actually very dangerous to stay away from that very area which creates the controversy and leads to potential payment by taxpayers of hard-earned money, because that's an easy target, to start from. And then all the peripherals that you're talking about would be just to fortify the position. So I would seriously urge the working group 3 to focus and get over this assessment of damages issue, because that's so important. And with these clear guidelines, then you would then, not be so concerned about inconsistencies, because you can have inconsistencies in terms of principles, but it actually hits the money award and where a nation has to actually pay. Makes a difference. Look at what happened to the Tatian Copper case. After 7 years of litigation, they came back to a settlement after the 4 billion award, and they gave the project back to Tatian Copper. And of course, the experts will now have to prove, right, that what they say works. And where's that 4 billion, right, that they will actually stand to lose. So it seems to me that Working Group 3 needs to come up with clear guidelines, and the experts should actually not play their own game, not have awards which are low for the state and very high. And tribunals have actually criticized the approach of experts, have actually made statements in some of the awards to say how unhelpful the experts are. So it seems to me that if you actually have clear guidelines of what can and cannot be applied in what situation, that would help parties to be credible and the experts to be credible, and then you would have a fair result that will not lead to this unfortunate criticism against ISDS, especially so that now that we are having exit coming to Singapore and trying to promote that, we don't want to be put in a position where Singapore is criticized for not, for having something and encouraging something which has this flaw in it. I'm sorry it took a bit long, but I think that's an important thing to actually talk about.
Would you like to take the floor and respond, or? Sure. I mean, but if there is anything you would like to say back, yeah.
It calls for a comment as to what it is that is holding.
Yeah, I can address that. Yeah. The reason that it's actually been looked at with some controversy in the Working Group 3 context is that there is a question as to whether discussion on assessment of damages is inside or outside the mandate of the working group. And that's actually the issue, because the working group mandate was to explore procedural type solutions or explore procedural reform to ISDS. So there are certain subject matters such as the assessment of damages, and for that matter, things like, how do we couch language on the right to regulate, things like that, which start to go into that gray area as to, is this procedural reform per se, or is this actually something that's veering into reform of substantive aspects of international investment law? There are, of course, delegations that do take the view that, if we understand the mandate to be, we have to fix ISDS, assessment of damages is part of that, but there is no clear consensus and it's not sufficient traction of that view for the working group to have then decided, okay, let's actually roll up our sleeves and deal this aspect as well. And just to also respond, thank you very much for flagging the case of Tetian v. Pakistan. And I fully agree with you that just like I mentioned that the CME in Lauder cases have become the poster child for how unpredictable or incoherent ISDS decisions could be, Tatian Copper versus Pakistan has also become a bit of a poster child for the abuse or the misuse of DCF. That being said, I'm actually quite heartened that in your comment, you're not saying that the DCF method per se is inappropriate, but that it is inappropriate in certain circumstances, such as when the cash flow predictions or the assumptions that have to go into the cash flow calculation are too speculative because the project is in its infancy. There is no actual cash flow being generated yet. But we do come back to the whole point that in an international investment dispute, where we're talking about monetary compensation, I suppose the locus classicus or the underlying legal principle that has to be somehow still upheld and respected is the principle articulated in the Hauser factory case, which is that of full reparation, and that is also currently it finds expression in the articles on state responsibility for internationally wrongful acts. So I would not take issue with the DCF method of calculation of damages per se, but to acknowledge at least that there should be some clearer sense by tribunals as to when it is appropriate and when it is not appropriate to use different types of income-based assessment methodologies. So I hope that responds adequately to the comment. And sure.
Yeah, there'll be time for networking and the questions afterwards, but I think there was a raised hand from the gentleman. Okay,
I'm holding the mic, so I'll just go ahead. My name is Wenlan Yang. I'm a research fellow from the Center for International Law. I have a question for Professor Meron. With the growing docket of the ICJ now, we also see that the court is quite burdened with new cases and new incidental proceedings. That may also have contributed to the longer period of time that is required for the court to dispose of a case. I'm wondering, in your experience representing states before the court, does that bother your state's clients at all? And if so, what would you recommend the court to do in order to reduce the time needed to process of a case? And I also have a second very short question for Ms. Ji as well. At the Center for International Law, we're very much concerned and interested in promoting our mediation as well. And I'm very interested in the convention on establishment of the IOMAD. I just wonder, there are a lot of competence restraints imposed in the convention, such as if there is a third-party interest involved, the organization will not entertain the case, or if the request for mediation concerns like maritime boundary or maritime interests or territorial sovereignty, the organization would also avoid that kind of disputes. I'm just wondering, like, how that kind of competence restraint will be exercised in practice. Would the Secretary General just throw that case out of the door even if both parties agree that they are willing to submit to the mediation procedure at the organization? Thank you.
Thank you very much for your question. In fact, among the 25 cases, there are some traditional pending cases brought by special agreement, like in the old days, and some of them are suffering. There is a case where I've changed 3 governments since the introduction with no, on a regular basis, elections and so on. The thing is, procedurally speaking, the court has to deal with provisional measures, and also the advisory opinions take precedence over some of the cases. And I know the court there are discussions within the court on its working methods, because indeed when you have a case which is going for a long time, especially when the relation between the two states is depending on the outcome of the case. It does not help advancing. And when I'm saying pending for a long time, it's more than 5 years and so. The thing is, the court is, they are only 11, the number at the registry is not very important, so there are human limits and financial limits to what the court can do. And I think what can be done is maybe to find a way to deal with the provisional measures requests, because there have been quite a number. I don't know, have it in a sort of a chamber dealt with or something like that. The thing is, there are trends, and there may be some of what's happening now, there may be a longer systemic change. So you don't know what is part of a trend and what is a systemic change. But the number of provisional measures has been so high in the past 10 years that I think something has to be done in order not to overburden the court with this. Also with the interventions, I think it may continue. And I don't think it just needs some reflection on the working methods. We don't need to change the statute, to change probably a little bit the rules, but that's not very difficult, I think. And while responding to the expectations of states to have their cases dealt in a timely manner. Well, this being said, it's not only the fault of the court, and sometimes states also find a way to prolong the cases. So.
Okay, answer to your question, I would say that the LMAD will not shut door to any disputes between states if all the states with the disputes wish to submit their dispute to the LMAD. The constraint that you mentioned in the LMAD Convention, it mainly refers to allow the states have flexibility when they join the LMAD. They may make by declaration to exclude certain categories of disputes that they would not like to submit it to the LMAD. And also they can waive such a kind of exclusion by submission of the specific case to the LMAD. Thank you.
Thank you so much. I think that my question could be for all the speakers, for anyone who is ready, who wishes to answer it. We hear a lot about the problem of double hatting, for example, of those arbitrators who act both as counsels, as arbitrators in different proceedings. But what maybe is not very much discussed is that in different dispute resolution methods, in international courts, in interstate arbitration, and ISDS, commercial arbitration, there are counsels everywhere. And as far as I understand, as far as I see, a lot of counsels, they act as counsels in different types of dispute resolution proceedings. For example, in international courts, in ISDS, in interstate and commercial disputes. So on like Euler sets, on Euler circles, there are a lot of those who are in this overlapping areas. To what extent, in your view, it could be beneficial for development of international dispute settlements, or there are more risks having in really different procedures people who are sometimes even the same counsels? Thank you so much.
The first is actually when there's double hatting as counsel and as arbitrator. Right. I mean, I don't see a problem with counsel acting in different fora. Frankly, I can't see what the problem is, because most of us here in the room will be doing it all the time. Right? Do you see a problem, my friend? No, we don't see a problem. Yeah.
I'm very sorry for eating. I mean, different procedures and maybe different perspectives. So if you are, for example, a counsel in ISDS and at the same time you help parties to mediate their disputes. I think that could, or for example, you represent states in advisory opinion procedure. There could be really a different perspective, and you bring your perspective, which is more usual for you, convenient for you, to another procedure.
Yulia, you're quite right? So this is evident in, say, Indian ad hoc. I mean, in India, the preference is the Indian, number of Indian lawyers here, you can correct me if I'm wrong, but in India, institutional arbitration is not popular. Ad hoc arbitration, and the practice is to appoint judges, right? Almost uniform practice is to appoint judges as arbitrators. So then the judges bring court-type litigation processes into arbitrations. So you're quite right. I think when counsel, say, appear in an arbitration and then fight a national court litigation, I think it behoves the counsel to bear in mind that the platform is different, the methodology is different, there are costs and speed, efficiency considerations, so you can't transplant. But I think that's our ongoing education as counsel. But I don't see really the kind of criticism that has been made in the international sphere to double hatting. So there is, I think there is one area where there is a concern. Let's say, prominent arbitrator / counsel X is a tribunal member in an ICSID panel. And then, on the other hand, he appears as counsel arguing the same treaty provision that is in dispute, which is going to decide in that ICSID panel, and then here he is 6 months before that making an argument. And so you get a sense that that's kind of going to be difficult, right? Because then how is he going to deal with it when his panel member, is he going to depart from his arguments as counsel, which is, So I think in that limited case, when you're dealing with the same kind of treaty provision, but I think that there is, in my view, Professor Miron and Judge Kolodkin might disagree, but I think the paranoia that you should not double hat at all, I think is going too far. But that's just my view, and I'm biased.
I disagree with that. No, I think what we are saying, it's on the contrary, it's really beneficial to have a different view. The only thing is you must be sure that you know where you put your feet in. And you can't go before a court and act like you would do before another courts, because what are the customs and the procedure before a court, you must know it before you go. So I think it really depends on the capacity to assimilate everything that's new in terms of procedure, and also the broader aspects. But there are two aspects to that. Normally, counsel is part of a team. So what's important is that you have a good team to have also the diversity of perspectives, but also those who are really well versed in the particular law of that court. So I think it's the balance within the court, and also, in the end, it's about international law. No, the international law is very specialized, but there is a central core to that. And sometimes getting back to the central core may help enlightening beyond the details of the case law, and may help bring some coherence in the mess that we have in some areas of international law. That would be my view.
If I may just add on, I do agree with what both Francis and Professor Miron have said. I too don't think that there is any particular ethical issue per se with counsel acting for different clients before different fora. In fact, if a counsel is able to do that effectively, then all the best to her for being versatile, flexible, and somehow able to adapt to the different fora. But it is it's beholden upon the counsel in the discharge of their professional duty to know the forum and not, in a sense, botch it up because they didn't understand that there was a particular culture or that they were not fully aware of certain unwritten rules of procedure before the forum. And then in such a situation, you might have the counsel end up doing a disservice to the client. But beyond that, I don't see that there is any problem in principle with counsel appearing before different fora. So, and bringing this back to the question, or rather the definition of double hatting or multiple hatting, the particular mischief that, at least in the ISDS reform space, countries have been trying to address is the issue of an arbitrator concurrently acting as counsel in the way that Francis has described, and also there are two additional bells and whistles that I will raise. One is it's not just multiple hatting as arbitrator versus counsel, but also arbitrator and expert. So there's also that angle of being double hatting as counsel, expert, as well as arbitrator. So that part is also sought to be addressed by the codes, the codes of conduct. And there's one additional aspect to that. It's not just multiple hatting at a concurrent point in time, but there's for reasons that I think Francis did allude to. What happens if you are an arbitrator who makes a decision today, and you're thinking that tomorrow I might be hired by XYZ client with a view or with a position that is adverse or opposite to the ruling that I would be inclined to make today as an arbitrator. So there is this time lapse angle as well. And so in order to address that mischief, the Ancestral Code of Conduct for arbitrators also has a bit of a cooling off period of 6 months or 3 years, depending on the circumstances in which the overlap happens. I won't go into the details, but that was also a very carefully crafted compromise position as to how much of a cooling off period an arbitrator must serve out before he can become a counsel in a case that involve either a similar treaty or similar issue or a similar party, as the case may be. Thanks. Oh, yeah, please.
For mediation, actually it's not quite double-hatting issues, but relating to it. The LMAD Convention made it clear that the mediator that in the specific case under the LMAD shall not act in any capacity that is in any pending or future proceedings, whether judicial, arbitral, or otherwise relating to the same subject of the dispute. Yes.
Well, we're well beyond the time, and of course there is less and less time for the networking, but I think, can I ask one final question, which would probably round up our discussion? And I think it is also important because it's a cross-cutting challenge, and it's kind of developing the question with respect to the consuls, and that question concerns the other side, the judges. So you may have heard of the famous play in the Russian literature, the Griboyedov's War from Wheat, and one of the phrases which has become an aphorism is who are the judges? And it seems like the international dispute settlement system is often blamed these days as well on the basis of the very same question, who are the judges? And that question does not concern only the persona of the judges themselves. So you already addressed the double hatting problem and things like that, but it also concerns the very authority of the authority that is issuing the decision. So the questions arise with respect to the formation of the tribunals, of the composition and diversity, the lack of diversity. Of course, this question probably concerns more ad hoc tribunals and less to lesser extent of the permanent standing mechanisms. But do you indeed think this is a cross-cutting challenge? And if so, what do you think could be done by the international community, or which steps could be, how to deal with this issue, besides by establishing standing mechanisms? Judge Kowalkin, if you, any volunteers? Yeah.
I'll volunteer, but I'm a member of a standing judicial body. So I think with respect to the standing bodies, you have these procedures crafted by states, by the major stakeholders, and they are usually enshrined in multilateral treaties. And I personally think that the existing criteria are enough to satisfy the issue. But sometimes you still may think of some additional things. For example, when chambers are being composed by the standing bodies, should these chambers also reflect the same representative, for example, criteria, geographic representation, or not? Or, for example, you were discussing this double heading and specifically concentrating on the issue of arbitrator becoming a council, for example. What about vice versa, for example? If a person pleads as a counsel in a case and then becomes a judge, even in a standing institution, and the person faces the same argument in a particular case, he or she was pleading beforehand. What would you think about the idea of just this particular person continuing to sit in this case and to judge upon the particular argument that was pleaded by that person in a similar case just some time ago? So there are still issues, of course. But if I may, I mean, Professor Meron herself is a counsel in a very different types of proceedings. And for me, for example, as a judge, it would be only beneficial to have a counsel pleading in front of the bench with the experience from having different backgrounds and diversified experience, public international law, private international law. It broadens the perspective. As I see it, many cases are involving very different issues. And sometimes you need a perspective of national law as well. So it's, I mean, for investment and private commercial arbitrations, it's a trite thing to say that, well, of course, national law, but also very much in public international law, interstate disputes. So I think it's a very beneficial thing. And may I make one more comment, since I'm still having the floor? It's on this transparency and mediation issue. For me, mediation is a very much a diplomatic, political and diplomatic exercise, not a purely legal one. And for me, I'm an old school person. For me, diplomacy is very much about non-transparency. It's about confidentiality. And this plea for transparency that we see everywhere, I mean, sometimes it could be harmful for diplomacy and for mediation. This was this song of many years ago, you don't remember it, some of you probably do. Love and marriage go together just like horse and carriage. I mean, diplomacy and transparency, mediation and transparency, in my view, do not go together like this at all. And it would be interesting for me even to know what place international law plays in mediation exercise by this new organization. Because among the principles I saw, correct me if I'm wrong, I do not see, I mean, enshrined in the convention, I do not see this a provision telling you that mediation must be exercised in accordance with international law and the outcome must be in accordance with international law. I wonder even if it has to be consistent with international law. Hopefully, yes, but it's a thing that should be done non-transparent and diplomatically and mostly, not always, but it's an interesting correlationship or relationship between the international law and mediation. But I'm sorry, yes, to get back to these issues.
I think we can end on love and marriage and force and carriage, unless I leave it to the moderator.
We should end here. Just to conclude, probably, I would like to thank our distinguished panelists for discussing all kinds of the trends and challenges in the international dispute settlement. And I think it definitely shows that there's some certain re-evaluation processes going on. And I hope that indeed our discussion today will further provoke a thoughtful analysis of the ways forward and the possible ways how to deal with the challenges that are there. Please join me in applauses for our distinguished panelists. Thank you very much to all of you, and please enjoy the networking afterwards. Thank you.